yesterday and agreed to. So I can
All right.
go up there and sign it as soon as this is done, Judge. If
Okay.
that.
He emailed, Mr. Kitchen emailed me a copy of that agreement, and I got it, and I also got your email confirming it, so we're all good.
Okay. Fair enough, Judge.
All right.
Okay. So I'm ready to begin, Judge. If
Sounds good. Let me call cases. We'll be on the record in two cases, those being 2019 CR 1246 and 2020 CR 580, both captioned State of Kansas versus Danny Sport. Would the parties announce their appearances, please?
May it please the court, Judge. Assistant District Attorney Viet Lay for the state.
May it please the court. John Kitchen appearing on behalf of Danny Sport, who is present by video for today's hearing. And Judge, for the record, I would like to note that yesterday when I went to the jail and spoke with Mr. Sport, we did discuss the fact that he does have a right to have an in-person hearing, or he could, if he wants to waive that right, we can do today's hearing by video. And Mr. Sport did inform me we can do today's hearing by video.
All right. Mr. Sport, you heard what your lawyer had to say. Is that correct?
Yes, sir.
Fantastic. All right. So, gentlemen, before we get on to the issue of this plea, there was set today a preliminary hearing. Obviously, we're not going to need that if we're proceeding with a plea. So, Mr. Kitchen, have you talked to your client about waiving his right to a preliminary hearing?
Yes, Judge. And again, if the court wants to, for the record, we can do it again, at this time.
That's okay. So, Mr. Sport, you understand what a prelim is, and
Yes,
and you're waiving that right today?
Yes, sir.
All right. Mr. Lay, is on behalf of the state, do you also waive a preliminary hearing?
Yes, Judge.
All right. I will find both parties have waived preliminary hearing. And at this time, bind the defendant over for trial. For the time being, I'll enter a plea of not guilty on his behalf until we get on with our rest of our hearing. Mr. Kitchen, waive formal reading of the information.
Yes, Judge. We waive both the information for 2020 CR 0580 and the amended information for 2019 CR 1246.
Great. All right. So, Mr. Kitchen, I'm sorry, Mr. Sport, we're ready to take up your plea today. To do that, I'm going to have to ask you a ton of questions, okay? If I ask you something, you don't understand it, tell me that. Okay. And you and I will talk about it until we're sure that we're on the same page.
Okay.
If at any time you want to talk to Mr. Kitchen in private before you answer one of my questions, just tell me that. I can we call it a breakout room. I can send you and he to a private room where you can talk without the rest of us hearing you, okay?
Okay.
All right. To get this started, I have to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Yep.
All right. Go ahead and put your hand up. Mr. Sport, how far did you go in school?
12th grade.
All right. You reading right okay?
Huh?
You reading right okay?
No. I was a special ed, but I get through it, you know what I mean?
Okay. So when you and Mr. Kitchen went over this plea petition, did he read it to you? Were you able to read that?
Yeah, he read it to me and explained everything to me.
Okay. You feel like you understand everything he told you was in it?
Yes, sir.
Okay. Now, I know you're in custody, but I have to ask you, at this time, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
And the only thing, last time I took a couple of days ibuprofen, but nothing else.
Yeah, those don't tend to cloud your mind. You feel like you're in a good place today, that you're clear in your mind?
Yes, sir.
All right. Do you understand what you've been charged with?
Yes, sir.
You know that you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would be entitled to a jury trial on these charges. Do you understand that?
Yes, sir.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. you would not have to prove anything yourself. Mr. Kitchen would help you throughout that trial. He would cross-examine and confront all of the state's witnesses, challenge their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power of court to make them come. At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, Mr. Le here could not argue to the jury, well, Mr. Sport must be guilty because he didn't tell you his side. You understand all that?
Yes, sir.
All right. Now, if we went through that whole trial and at the end of it, you were convicted, you would have a right to appeal that conviction to the appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes.
All right. Now, if we go forward with this plea today and I accept this, you decide this is what you want to do, there's not going to be a trial of any kind in this case, and you're going to be giving up all of those rights that I just talked about. You understand that?
Yes.
All right. Now, I'm going to share a screen here with you that has the plea petition that Mr. Kitchen sent me. I want to ask you first as it comes up. Can you see that?
Yeah.
All right. Does that look like the plea petition that Mr. Kitchen went over with you?
Yep.
All right. I want to specifically go down here where there's a signature. It says defendant. Looks like it says Danny Sport. Is that your signature?
Yes, sir.
All right. Now above that on our screen here is what we call the plea agreement. And I'm going to read it to you, and I want to make sure that I have this right. In the 2020 case, you're agreeing to plead guilty to count 3. That's interference with a law enforcement officer, a severity level 9 non-person felony, and count 4, which is criminal possession of a firearm, which is a severity level 8 non-person felony. Do I have that right, Mr. Kitchen? An 8?
Yes, Judge, it's a level 8 non-person felony.
Thank you. The state's going to dismiss the rest of the counts in that case. In the other case, you're going to be pleading guilty to possession of methamphetamine, which is a severity level 5 drug felony, and count 2, attempted theft, a severity level 10 non-person felony. The state's going to dismiss the rest of the counts in that case as well. Both parties are going to recommend that I grant a downward departure to a controlling sentence of 28 months?
Yes, Judge, it is 28 months.
Okay, to a controlling term of 28 months for the 2 cases with consecutive sentences. Is that your understanding of the entire plea, Mr. Sport?
Yeah, 20. Yeah. 28.
Okay.
Prison. Yeah.
Has anybody promised you anything other than what I just read to you to get you to plead guilty today?
No, sir.
Anybody placed any force or threats against you to make you plead guilty today?
No.
Okay. Now, it talks in here about recommendations for sentences. You understand that while I'm going to listen very closely to the recommendations of the parties and take them into full consideration, I'm not bound by those agreements or part of them, and I can sentence you to any sentence that the law allows me to. Do you understand that?
Yes, sir.
Okay. So given that, what I have to, Mr. Kitchen, what do you believe your client's criminal history to be?
Judge, I believe he will fall in the A box on the Kansas sentencing grid, presumptive prison.
Okay. So normally I would be concerned about these 2 convictions cross scoring against each other, but if he's already in A, then that's not going to matter. Do you agree with that, Mr. Kitchen?
Yes, Judge.
Okay. All right. So, Mr. Sport, what I have to do then is just assume that the lawyers are right and that you're criminal history A, and therefore I can advise you what the maximum sentence in these cases are.
Okay.
I see here in the plea petition, it says 42 months imprisonment, and the fine is not.
Judge, that is my fault. I meant to look it up. I did talk about the full range of fines and the law, but the specifics for this grid, I just forgot to put it in there. That is my fault.
And so it's actually $100,000 for
Yes, Judge.
for each count. You understand that, Mr. Sport, that that's the maximums?
Yes, sir.
All right. And Mr. Kitchen, when you calculated this, I usually do this before we got on, but I got it rather late as this kind of came in. Is that 42 months kind of adding up the maximums for all of the different counts?
No, Judge. What I did, Judge, in the plea agreement is I took the highest level felony
Yeah.
range, which is the level 5 drug felony in the 2019 case.
Okay.
We can, if the court would like to, we can do the math at this time, but it's kind of complicated with the limited space I have with the plea petition provided for him.
Right. I understand all of that. So you understand, Mr. Sport, that 42 months represents the high number in the box for the severity level 5 drug felony,
Yes,
but that the other counts I want to kind of put your mind at rest here. I don't intend there. I don't see any reason why I would not follow the agreement that these two fine lawyers have worked out in this case. But I am under a duty to advise you of what the maximum possibles are.
Yeah.
So each one of these counts could be run consecutive. So not only that 42 months of the in case number or the 2019 case, but the remaining count in that attempted theft, you could be sentenced to the maximum box in the I category. Anybody off the top of their head remember what
I think 7 months on that one.
7 months?
Something
I
like
think that sounds right, because I think it's 5, 6, or 7 months for a 10I. So then in the other case, the 2020 case, the highest level there is that possession of a firearm, which is a severity level 8. Can
23
someone tell me what the top of 8A is?
23 months.
That is correct.
All
Yes,
right.
Judge.
So that 23 month right there. And then finally on the obstruction charge, which is a 9, and it would be an I for scoring since it's secondary.
7 months.
I think that's 8, right?
Okay, you're
7
right.
months.
7 or 8
months.
months.
Okay. So, Mr. Sport, I'm pretty impressed because it seems like you know this off the top of your head better than the rest of us.
It's crazy.
But you understand that as a maximum, that's what the most that anybody could face if a judge were to give you the maximum for each count and run all of those consecutively. You understand that?
Yes, sir.
Okay. All right. So do you have any questions for me about anything that we've gone over today?
The only thing I got, if you taught me, I would like for you to, when I go to prison, put me in drug treatment somehow, if you can. Man,
All right.
forward that. That's all I ask for. 'Cause I need-
Okay. Well, I can tell you the way it works. So if you were to be granted probation, which it doesn't look like part of this plea, then I could order part of your probation to be drug treatment. When it involves going to DOC,
Yeah,
they'll take you down to the reception and diagnostic center, and then they're going to do an interview with you to figure out what your needs are. They're the ones that get to do that. And I guarantee you, if you tell them you have a drug problem, that first thing they're going to do is get you into a treatment program. Okay.
okay. That's what I'll do
All right.
then.
Super.
Thank
All right. Mr. Kitchen, do you know any legal reason why your client should not plead?
No, Judge.
All right. Then I'm going to formally ask you, Mr. Sport, as to count 3 of the 2020 case, which charges you with interference with a law enforcement officer, and that's a severity level 9 non-person felony. How do you plead, guilty or not guilty?
Guilty.
All right. And as to count 4 of that information, charging you with criminal possession of a firearm, a severity level 8 non-person felony, again, guilty or not guilty?
Guilty.
in the 2019 case as to the information charging you with possession of count 1, possession of methamphetamine, a severity level 5 drug felony, guilty or not guilty?
Guilty.
And count 2, attempted theft, severity level 10 non-person felony, guilty or not guilty?
Guilty.
Thank you. All right. I am going to find that the defendant has freely, voluntarily, and intelligently entered into this plea. He understands the nature of the charges and the consequences of, I'm sorry, before I get to that, I need to ask Mr. Lay, could you relate to the court what the facts in these two cases are that would support a finding of guilt in the two cases?
Yes, Judge. Judge, if this matter were to proceed to trial, the state would prove that on October 31st, 2019, Officer Zhang and Peters of the Wyandotte County Sheriff's Office responded to 6020 Sewell Avenue, Wyandotte County, Kansas City, Kansas, with regard to an attempted theft report. Upon arrival, the officers contacted the victim, James Raymond Vorgan, who advised that an unknown male driving a Dodge pickup truck, wearing a black jacket, attempted to take his Ferris IS 3100 zero-turn mower valued at $12,000 without the victim's permission. Upon seeing the suspect, the victim confronted the suspect, and the suspect escaped. Officers Leal and Lowney of the Kansas City, Kansas Police Department were in a marked patrol vehicle in the area of North 32nd Street and Ohio Avenue, Wyandotte County, Kansas City, Kansas, when they observed the suspect vehicle in the aforementioned incident. They were given the suspect vehicle information from the Wyandotte County Sheriff's Office and completed a vehicle stop and identified the driver as Danny Wayne Sport. They conducted a computer check and indicated that several warrants were out for the defendant's arrest. And in a search incident to this lawful arrest, they seized a quantity of methamphetamine, 1.6 grams. When the defendant was in the prison and given his Miranda warnings, the defendant admitted to driving by the victim's house and attempting to take the lawnmower without the victim's permission. Those are the facts in the 2019 CR 1246 case. Should I read the facts for 2020 CR 580? Judge?
Let me ask Mr. Sport, first of all, you heard what the prosecutor had to say about that 2019 case. Is that what happened?
Yes, sir.
All right. Mr. Lay, thank you. Now, please relate the 2020 case.
Yes, Judge. Judge, if this matter were to proceed to trial, the state would prove that on August 21st, 2020, officers of the Kansas City, Kansas Police Department were dispatched to 8600 State Avenue, Room 7, Kansas City, Wyandotte County, Kansas. Officers made contact with the victim, Melena Bunch, who advised the officers that the defendant pushed her against a wall, produced a black 9mm handgun, and put the barrel of the gun into her stomach. Officers subsequently checked the area for Mr. Sport, or for the defendant, Mr. Sport, saw him jump a fence and run northbound into a wooded area. Uniformed officers of the Kansas City, Kansas Police Department then gave Mr. Sport verbal commands to not move and to show his hands. The defendant did not comply and was entangled in brush. Officers pursued the defendant while the defendant was attempting to get off the ground. Officers gave verbal commands for the defendant to show them his hands, which were underneath him. The defendant refused, and officers had to pull each arm from underneath his body. After taking the defendant into custody, officers searched the area and took Mr. Sport into custody and located a Taurus 9mm handgun, serial number TMD 48105, 10 to 15 feet away. In prison, the defendant was submitted a DNA sample, and later testing of the handgun revealed the defendant's DNA on the trigger and on the slide. Officers later found out that Mr. Sport is not allowed to possess a firearm based on a felony aggravated burglary out of Johnson County, case number 19CR1246, for which the defendant was convicted on October 28th, 2009, and released on April 15th, 2017.
All right. Mr. Sport, you heard what the prosecutor had to say about the 2020 case. Is that what happened in that case?
Yes, sir.
All right, thank you. Now I can find that the defendant has freely, voluntarily, and intelligently entered into this plea. He knows the nature of the charges and the consequences of the plea. His decision to plead guilty today is not the product of any force or threats placed upon him or promises made to him. The state has provided a sufficient factual basis for a finding of guilt in the two cases, and the defendant has acknowledged those facts. Therefore, I will find him guilty in case number, or the 2019 case of counts 1 and 2, that being the possession of methamphetamine, the attempted theft, and in 2020 case counts 3 and 4. Per the plea agreement, the rest of the counts are dismissed. I'm going to order that a pre-sentence investigation be conducted, and I will continue the sentencing pending receipt of that. Gentlemen, I was hoping that my assistant would be able to get back with me with a date prior to us completing this, but she has not. And since Mr. Kitchen is going to be taking his client's PSI request over to him to fill out that information, we will wait for that. And I'm just going to send an email including both of you gentlemen and my assistant, requesting that a date be set up, and we'll get it done as fast as we can, okay?
Sure.
All right, Mr. Sport, good luck to you. We'll see you here in a couple of weeks. It takes at least that long to get this PSI done, but hopefully we can get this done and get you on your way. Look, my hope is I'm really encouraged by you actively seeking treatment as fast as you can. I think that's a giant first step in getting past this. I know you're a criminal history aide, but I'm optimistic that this could be your last go round here. You can get this stuff behind you. You're still a young man, and be able to get on with life. So we'll work on that, and we'll see you in a couple of weeks. Okay.
So I'm getting a 28-month prison then?
We have to do a pre-sentence investigation and do a sentencing hearing. But I can tell you that I see no reason why I would not follow the plea agreement that
Right.
these gentlemen have worked out. Okay.
All right. And another thing, can you send me a copy of the PSI for me?
Mr. Sport, as I explained yesterday,
Oh, yeah.
okay,
Okay.
I'll get it from the PSI writer and I'll send you a copy and we'll review it sometime
Okay.
before your sentencing date, whenever that
Right.
is.
Yep. Okay.
Right.
All right. Anything else for our record today?
Nope.
No,
Thank you,
Judge.
guys.
None for the record, Judge, just general question. As I
Yep.
said, the court, I'll swing by the jail tomorrow because I have to
Okay.
be in the traffic docket in the morning. Does the court just want me to physically deliver the PSI request to your chambers or just email it to you?
You can email it to me, and I'll get it over to probation.
Very well, Judge.
All righty. Thank you all. Have a good day.